all, I don't need to take the court to the actual injunction that was granted in this case. You have well in mind the important points that it provided for a review after 1 year and was revocable, and twice stated that it was revocable.
Sorry, you're going to have to speak up a bit, Mr. If you don't mind, please.
And the other important point is that it was addressed to the whole world. Its wording was, it is...
Where is the injunction?
It's at 207.
In what? In what, Mr. Anderson?
In bundle 1.
Thank you.
The paragraph I was just referring to is paragraph 1 on the next page.
It is forbidden for anyone.
Yes. To set up an encampment and so on. Now, although Wolverhampton had suffered this problem over a period of time, at the time that the injunction was granted, there were no encampments. The authority had gone to court in order to stop it happening again as a preventative measure. So this was an exclusively precautionary injunction, and there was nobody committing the behaviour, so there were no defendants at the time that it was granted. A feature that the judge noted in the paragraph 117 that Mr. Giffen took you through. So the injunction didn't bind any defendants. It bound the claimant to the extent that it imposed obligations. And neither was it declaratory of anybody's rights over any real property. Your Lordship has seen already that it was a provisional order as well. It was to last for a year, and it would only become binding on somebody if they became a perpetrator of conduct which it forbade. So it was to that extent a provisional order and a conditional order. And obviously, anybody who either became a defendant by committing the conduct or who wanted to commit the conduct and took the more prudent course of applying to the court to vary the order, in either case, that person would be heard. So although it didn't provide for a return date and was not expressed to last until a trial, it did contain provisions for its own review, expiry, or renewal. Plainly, this was not a typical interim order of the sort that Lord Diplock had in mind in the Siskina. But neither was it an ordinary final order in the sense that Lord Diplock was familiar with in other shipping cases. Now, because there were no defendants, although it named defendants as persons unknown, it was, as the judge rightly recognised, in reality, an injunction against everyone, against the world. Indeed, from Wolverhampton's perspective, it appears difficult to suggest that any injunction that binds newcomers isn't to that extent an injunction against the world. Ex hypothesis. But nothing much turns on that sort of classification. It was reviewed. It was reviewed twice. The first time, we don't need to go to the transcript, it was reviewed by Mr. Justice Stuart Smith, as he then was. The only interesting feature of the hearing, really, is that His Lordship treated the hearing, the applicant's counsel, Ms. Caney, he asked her if there was anything that he should know about that he would have to be told on an application without notice. He treated it as that type of a hearing. But the more interesting and significant review was the second one, which occurred in July 2020 before Mr. Justice Martin Spencer. I would like to take the court to that, to his judgment, not to the transcript of the hearing, which is at page 331 of the same bundle.
331, did you say?
Yes. He recites the history, and then we can go straight to paragraph 13. But by now, some significant developments have occurred. Firstly, the transit site has planning permission, but it hasn't yet opened. Secondly, Bromley's been decided, and thirdly, Candidate Goose has been decided in this court as well. In paragraph 13, His Lordship observes that now the planning permission has been granted, it may be thought that the review wasn't really necessary. But he says, but now Bromley's been decided, we need to take another look at this order, which is precisely what he then does. And he says in paragraph 14, the Court of Appeal took the opportunity to give guidance in these sort of cases, and given the clarification and exposition of the law set out in the Bromley case, it has been thought appropriate for the review to proceed so as to titrate this injunction, in this case, with the principles that were set out by the Court of Appeal in the Bromley case. To a certain extent, though, the Court of Appeal have preempted the review by referring in the course of the judgment, largely with approval, to the terms of the order made by Mrs. Justice Jefford. Nevertheless, it is appropriate to carry out this further review, not just because of the decision in the Bromley case, but also because the Court has had the advantage of considering written submissions on behalf of the National Federation of Gypsy Liaison Groups by Mr. Christopher Johnson of the Community Law Partnership, my Lord, who sits in court instructing the interveners today, for which the court is grateful. He goes on, so the point to be taken from that is that His Lordship proposed to examine the injunction against the criteria suggested or laid down in Bromley. He quotes from the Bromley judgment fairly extensively in the ensuing paragraphs. And he says this at paragraph 20. This isn't an appeal, this is not an appeal from the decision of Mrs. Justice Jefford to grant the initial injunction on the 2nd of October 2018. However, given the provision for review and given the significance of the decision of the Court of Appeal in the Bromley case, had I considered that her decision or that of Mr. Justice Stuart Smith fell foul of the principles set out by the Court of Appeal, I would have considered it within my power and duty to consider afresh the injunction granted in this case, so as to give full effect to the review process.
Which he couldn't have done if it had been a final injunction.
Which he couldn't have done, exactly, if it hadn't provided itself for a review. So we say that he was right in his approach, and obviously also say that he was right to say, as he did in the next paragraph, that this injunction was Bromley compliant.
So how did this then come before Mr. Justice Nicklin?
Well, there were a number of cases, obviously, and the short answer is it was called in of the court's own motion.
He called in a number of cases for review, didn't he?
Yes, he obtained the permission, I think, of the president of his division, and with her concurrence, called in all of the traveller cases.
But how did he have jurisdiction to review? I suppose he did under the terms of the order which continued with its power to review, is that right?
We didn't oppose his jurisdiction. We in fact supported it, although we said that the injunction should not be discharged. Ms. Bolton challenges his jurisdiction, and your lordships will be hearing argument about that in due course from her.
But not in this case.
Well,
She can't. She doesn't act for Wolverhampton, you do.
oh, I'm sorry, not in this case, no, but argument that we would have advanced if we had chosen to take the point, which we didn't. I mean, it's fundamental to our approach that this is not a final order in the traditional sense, and therefore the fundamental principle is not breached by it. And that brings me on to the fundamental principle.
Was there ever a trial?
Mrs. Justice Jefford regarded herself as conducting the trial. There was a lot of evidence, which I haven't drawn the court's attention to. There wasn't oral evidence, but there was no cross-examination. But she received a very large volume of evidence, which she reviewed and came to factual conclusions which are recorded in her judgment.
I mean, it's a bit odd, isn't it?
Yes.
So you have an interlocutory application, an interim injunction, a trial or a further hearing with loads of evidence but no cross-examination, I take it.
No.
And a sort of interim plus order, which is then reviewed
There was
according to the changes and the vagaries of the law, as opposed to the facts.
There was no interim injunction. The hearing before Mrs. Justice Jefford was the first hearing, apart
Right.
from properly so-called interlocutory hearings about service.
But it was an interlocutory hearing.
No, it was regarded by the parties as the hearing.
Okay.
And Mr. Justice Nicklin characterised the injunction as a final injunction, and rightly so, although where he went wrong was to consider that that had any particular significance.
Yes.
And his eventual decision, as the court knows, was that Mrs. Justice Jefford and Mr. Justice Stuart Smith and Mr. Justice Martin Spencer had all been wrong to grant and continue this injunction because it is a legally incompetent beast.
A legally incompetent what?
Well, I said beast, but a legally incompetent construct, that you can't have them. And his decision on that starts at paragraph 224, at page 90 of the first bundle. Mr. Giffen's already taken you to it, and I concur with his submission. The judge was right to find that he had jurisdiction to grant, or that Mrs. Justice Jefford had the jurisdiction to grant the order. But his decision was that it was a jurisdiction that should never be exercised by reason of a self-denying limit, as he put it in paragraph 224, on the grant of contramundum orders, because that gives effect to a fundamental principle of justice explained by the Court of Appeal in Canada Goose. In fact, he goes on to cite the fundamental principle which Canada Goose had cited from Spycatcher case. We say that whilst it is, of course, a fundamental principle of justice that a person cannot be made subject to the jurisdiction of the court without having such notice of the proceedings as will enable him to be heard, that the judge overplayed that fundamental principle to the exclusion of other fundamental principles. And anyway, in this case, that fundamental principle was not breached. Another fundamental principle that's just as important is that enunciated by Baroness Hale. In the Mayor case, where there's a right, there should be a remedy. for example. The fundamental principle derives from a series of cases that we briefly analyse in paragraphs 31 to 35 of the skeleton argument. And for reasons of time, I don't propose to repeat that analysis orally. I couldn't add anything to it. The point to be taken from the analysis is that in none of the cases, Iverson, Marengo, or Spycatcher, did the courts explore the limits of the court's power to grant against the world injunction. Indeed, none of those three cases concerned against the world injunctions. If we look at Lord Oliver's speech in the Spycatcher case, this is in the Authorities Bundle A. It's the first authority. It was an injunction against the Observer, I think, and the Sunday Times was in trouble for publishing that which the Observer had been enjoined against publishing. And it was never the Crown's case in this application for contempt of court that the injunction was binding on the Times. It was specifically argued on the basis that this was a criminal contempt to do with the upholding the course of justice and the court's processes. But at page 200, internal to 224, our page 34, having disposed of one difficulty that needn't trouble this court today, Lord Oliver went on the third line of page 34 to deal with a second objection which troubled him. Equity in general acts in personam, and there are respectable authorities for the proposition that injunctions, whether mandatory or prohibitory, operate inter partes and should be so expressed. But although, as Lord Justice Bolcombe pointed out in the Court of Appeal in the instant case, there may be an exception in the case of the court's jurisdiction in wardship. The appellants argue that to invoke the jurisdiction in contempt against a person who is neither a party to the order nor an aider or abettor, but who has done what the defendant in the action was forbidden by the order to do, is in effect to make the order operate in rem or contra mundum, if that expression is preferred. If then it is argued that it is assumed to be the purpose of the court in making the order, the purpose is one which the court cannot legitimately achieve because, as the authorities referred to demonstrate, the order is only properly made inter partes. There is an appealing logic in this, but the answer is, I think, that it confuses two quite different things. That is to say, the scope of an order made in private litigation inter partes and the public law question of the proper administration of justice. If the court has taken into its hands the conduct of the matter, to the extent of ordering the interim preservation of the interest of the plaintiff, so that the issue between him and the defendant can be properly and fairly tried, it has to be accepted that that is what the court has determined that the interests of justice require. Gratuitous intervention of a third party intended to result in that purpose being frustrated and the outcome of the trial prejudiced must manifestly interfere and obstruct with what the court has determined to be the interests of justice. Those interests are not dependent upon the scope of the order. The appellants fairly take the point that the third party who learns of the order and is thus put in the position of considering whether he is at liberty to do that which the party to the order is forbidden to do, has not been heard by the court, and has thus not had the opportunity of putting before the court any arguments which he may have for contending that he's free to do what he desires in his own interest to do. That is perfectly true, but the answer is surely that is by his own choice. The Sunday Times in the instant case was perfectly at liberty before publishing, either to inform the respondent and so give him the opportunity to object, or to approach the court and to argue that it should be free to publish where the defendants were not, just as a person affected by notice of, for example, a memoranda injunction is able to and frequently does apply to the court for directions as to the disposition of assets in his hands. And he therefore rejects the argument. So, Lord Oliver in the end does not think, in fact, that the fundamental principle is breached or offended by the spycatcher effect, by the order being effectively binding on third parties. And the reason he isn't troubled in the end by it is that third parties can apply to the court to set the order aside as it affects them. So obviously,
did the order in Spycatcher affect the world?
No. Its interpretation was open to question, but Mr. Law's QC for the Crown expressly stated that he didn't contend for that construction.
The whole appeal was argued on the basis that the Times, Sunday Times, were not bound by the order.
Exactly.
And the appeal was on the reasoning of their lordships, as it seems to me at any rate, was all on the basis of interfering with the prospective trial of the action which the court had decided to hold, and in relation to which it had granted the interim injunction against the observer. And what Lord Oliver is saying is nothing to do with setting aside or varying the order made against the observer. What he's suggesting in the passage you've just shown us is the Times going to the court and saying, well, this order may well bind the observer, but it shouldn't bind me.
Yes.
He's not setting aside, doing anything with the order.
I accept that, yes. Yes, it's different in that sense. Because in our case, if somebody applied to set aside the Wolverhampton injunction, they may wish to argue that the whole thing should be set aside. But the terms of our injunction do permit that. So that the principles being enunciated and the reassurance that Lord Oliver derived from the ability of somebody to apply to the court applies equally in principle in this case as it did in that. I accept, of course, that there are practical differences between the Sunday Times applying urgently to, the Sunday Times applying to the court to vary an injunction against publication, and a gypsy or traveller family doing the same. Conceptually, it is the same point. So if we can come now to how that principle, that reassurance that Lord Oliver derived, finds its way into the traveller cases, and of course that is the Gamble case. The injunction that was granted, this is at page 165 of the Authorities A bundle. But the injunction, which I want to show you first, is at page 173. 174, I'm sorry. This court granted an injunction against persons unknown, other than some named defendants, causing or permitting hardcore to be deposited, or caravans, mobile homes, or other forms of residential accommodation to be stationed on the land. And the Ms. Gamble, who breached the order, was herself a newcomer. She put her caravan on the land after the order had been made. And the issue on the appeal is recited in paragraph 6 of the judgment of the Master of the Rolls, which we have to scroll back to page 169. There were two appeals that raised the same issue. Whether and in what circumstances the approach laid down by the House of Lords in South Bucks District Council in Porter applies to cases like these where an injunction is granted not against named individuals occupying caravans on land without relevant planning consent, but against unnamed individuals who were not in such occupation when the injunctions were granted. Paragraph 27 the argument which gave rise to that issue.
Sorry, you've lost me, I'm afraid. We're in Gamel,
Yes.
and which tab is Gamel?
I've taken the court to the terms of the order, the date of the breach.
Yeah, just hang on a second. Which tab is Gamel? Or which page in the bundle?
It's tab 8 and it's page what? I'm now at page 175.
Yeah, which was the paragraph you were reading before, which I'm afraid I lost?
Paragraph 6, towards the beginning.
6. And now where are you?
And now 27.
Yeah.
So the argument that was advanced, which gave rise to the issue recited in paragraph 6, begins at the top of page 176. It was submitted on behalf of the defendants that the court should carry out the balancing exercise in the South Bucks case when, as counsel would put it, the particular person becomes a defendant in each case. So what was being submitted was that the consideration of proportionality and the overall justice of the grant of the injunction against this defendant should be considered again if she breaches the order before she is said to become a defendant. And the answer to that argument begins at paragraph 32 on page 178. In each of these appeals, the appellant became a party to the proceedings when she did an act which brought her within the definition of defendant in the particular case. I don't think I need to read the rest. If we go to paragraph 33, just at letter G, there are 3 numbered propositions. The principles in the South Bucks case set out above apply when the court, that's the Porter case, apply when the court is considering whether to grant an injunction against named defendants. They do not apply in full when a court is considering whether or not to grant an injunction against persons unknown, because the relevant personal information would ex hypothesi not be available. However, this fact makes it important for courts only to grant such injunctions in cases where it is not possible for the applicant to identify the persons concerned or likely to be concerned. So he's referring also to precautionary injunctions. The correct course for a person who learns that he is enjoined and who wishes to take further action, which is or would be in breach of the injunction and thus contempt, is not to take such action but to apply to the court for an order varying or setting aside the injunction. My lords, that echoes Lord Oliver's answer to the problem with the fundamental principle, and it echoes it specifically in the context of a traveller case. So the court clearly took the view in Gamel that the ability to make an application to the court before undertaking the forbidden conduct is sufficient protection and does not make it wrong in principle to grant such an order.
And there's nothing here about this being limited to interim orders.
Nothing, no. And Ms. Gamel lost her appeal. So it was a suspended sentence, fortunately for her, but otherwise she would have gone to prison as a result of this decision. The court couldn't have reached this decision that Ms. Gamel was in contempt of court if it had considered that the injunction had breached the fundamental principle.
What the Master of the Roll says at the end of that paragraph on page 672 is quite significant, potentially. Principles in the South Bucks case are irrelevant to the question whether or not the person is in breach of an injunction and or whether he's in contempt.
Sorry, where's that?
Sorry, it's just subparagraph 7 at the end of
7.
paragraph 32.
Well, that's right. The Master of the Rolls was saying that she should have applied before putting her caravan there, not afterwards. And in fact, she didn't even apply afterwards.
But did she know of the order?
Yes, she did. And she couldn't be in contempt of court if she hadn't. She became a defendant when she went onto the land with the knowledge of the order. And there isn't a problem with service in terms of bringing it to her attention, because there's a big sign on the land to tell her about it. And in fact,
Right, so she couldn't read or write.
she couldn't read, but it was explained to her.
But paragraph 24 is where
Yeah.
Master Laws explains how it was she became bound by the injunction.
Now, according to the judge, in paragraph 235, this is just an example of a temporary injunction where the inability to, the injustice inherent in the inability to carry out the South Bucks full examination is acceptable because it's a merely temporary position pending a trial. But there's nothing in the judgment to suggest that that was in their lordship's mind. And the injunction in Gamble was not awarded on an interim basis to enable the claimant, South Cambridgeshire, to identify some more defendants. It was awarded for the opposite reason, to prevent people from becoming defendants. It was urgent protection ahead of a trial, and we submit it must have been in the. It's a concomitant of this decision that the court thought that a final injunction could be awarded at a trial in due course.
So you say Canada Goose is inconsistent with this decision?
Well, Canada Goose was a final order. This was in fact an interim order, but yes, we say that it is conceptually inconsistent because it must have been in the court's mind. In this case, I mean, what was in the court's mind we don't know, but it follows from the court's reasoning in this case that it would have granted a final order. And that's why it granted.
But that can't be the right reason. It follows from the court's reasoning that the objection that Canada Goose uses to the grant of a permanent injunction is not a valid objection on the authority of this case.
Yes, that's right. Thank you.
So it was ratio of this case that objection is not valid, and yet Canada Goose decided that objection was valid.
Yes, it was indeed, yes.
Yeah.
But anyway, the judge's reasoning, and I suppose the reasoning in Canada Goose, but I'll come to distinguishing that case in a moment, because I know it's no good for me in this court to persuade you that that decision was wrong. But the logic of this case is that you can have a final injunction, in this sort of case at least, of the type that Wolverhampton obtained. And where the judge went wrong was insisting that there was a fundamental distinction. If we look at the judgment of paragraph 162, he said it's the starting point. And this explains why he went wrong. The distinction between interim and final orders is his starting point. At the very beginning of the section headed decision, where he disposes of the submissions we made below, the court has the power, it's an exceptional power to make contramundum orders, and 162, the advocate to the court has identified the correct starting point, recognition of the fundamental difference between interim and final injunctions. Quoting the Siskina. Now, of course, Lord Diplock in that case was speaking of injunctions intended to preserve status quo, as he put it. But that isn't the only sort of interim order, and we submit that this is not a fundamental distinction at all.
Well, the status of Lord Diplock's judgment in the Siskina is now very precarious indeed.
It is, yes, and Mr. Giffens touched on that. But we don't even need to go that far, because Lord Diplock was simply not talking about this sort of case. He was talking about a quite different case.
Well, I mean, unfortunately, I'm quite familiar with Lord Diplock's judgment in the Siskina, and he was actually talking about all kinds of injunctions, because he relied on North London Railway for what he was saying, and that was the objection that was taken. And over 50, 60 years since the Siskina, that has been diluted by the Supreme Court and the House of Lords. But you don't need to say any of that, really, because at the very least, Lord Diplock's, any distinction between interim and final from the Siskina is not really what was being relied upon. What was really being relied upon was the fundamental principles that were breached.
Yes, and it's apparently the judge's view that the fundamental principle is breached if it's a final order, and not if it's an interim order, or perhaps it is breached in the case of an interim order, but that's all right because it's provisional and strictly conditional. But the fundamental principle is not breached by an order that specifically contains the protections that this order contains. That was Lord Oliver's view, and it was Sir Anthony Clark's view as well. And this leads to the illogicality of paragraph 170 of the judgment. 172, I'm sorry. Where his lordship attempts to justify the Gamble principle at the interim stage. But he only manages to do it by positing that he's got at least one known identifiable defendant. Providing the court's jurisdiction has been established over a defendant by service of the claim form, whether a named defendant or a person unknown in respect of whom service of the claim form can be affected by an alternative service order, then there is jurisdiction to grant an interim injunction in terms which will apply not only to those who've already carried out the allegedly wrongful act, but also newcomers. And the problem with that is that it goes straight back to the problem that the Chancellor identified in the Bloomsbury case that Mr. Giffen's already spoken about. The problem that you can get complete relief against the whole world, provided you've got one identifiable defendant. But if you haven't got one identifiable defendant, you can't get any relief at all. Can we go to the Bloomsbury case?
It can't have made any difference to Mrs. Gamble whether anybody had identified a named defendant.
No.
She turned up with her caravan, and she was on the wrong end of a contempt application.
That's right. And she went to the same prison as if it had been a final order, or would have done if she'd gone there.
Yes, Bloomsbury.
Bloomsbury. This is tab 3 of the main bundle, authorities bundle.
This wasn't appealed.
I'm sorry,
It wasn't appealed.
it wasn't appealed. The injunction is set out at page 88. And after argument, it had been amended to this at letter F, and included persons who has or have physical possession of a copy of the book. So it did in fact have an potential effect against the whole world, because anybody who came into possession of the book after this order had been granted would have been subject to this order.
And the order was time limited until the 21st of June, which I think was publication date, is that right?
The publication date was the 21st of June. The order, it was an interim order, but only because publication was imminent. If publication hadn't been due for another couple of years, then this would have had to have come on for trial.
Yeah.
And according to the judge, no order would then have been available at the final trial.
According to the judge in this case.
Yeah, according to the judge in this case, yes. We go to page 90, the bottom. The Chancellor identifies the problem I've just spoken about. Having one identifiable defendant makes you, gives you a privileged position against the whole world that you don't otherwise have. Paragraph 17 on page 93, I would draw your attention to. Counsel for the claimant was worried about the jurisdiction. And I think paragraph 17 is worth looking at just because it makes clear that no one had any idea who was in possession of the book or who might come into possession of the book. This was an injunction against the world insofar as it was tempted to get its hands on the book. And then at page 94, His Lordship concludes that the claimants are entitled to bring the action as constituted at letter D, and at letter F says the crucial point is that the description used must be sufficiently certain as to identify both those who are included and those who are not. If that test is satisfied, then it does not seem to me to matter that the description may apply to no one or to more than one person, nor that there is no further element of subsequent identification, whether by service or otherwise. Now, not only was this an injunction against the world, but it had the equivalent effect of a final order because of the publication date. So I come next to Cameron.
And this has not been overruled by the Court of Appeal?
No, it was spoken of in Cameron with apparent approval. Now, at least Lord Justice Longmore in Ineos thought it was approved in the passage that Mr. Giffen has shown you.
Can you just tell me the reference for where Cameron speaks of this with approval?
Yes. It begins at paragraph 11, I think, from memory. I'm just scrolling now. Page 282.
10.
Sorry, 10, yes. letter D.
He says, since this decision, the jurisdiction has regularly been invoked.
Lord, this is what this is why the injunction cases come to be discussed in the Cameron judgment, because the Court of Appeal had relied on Bloomsbury and I think other cases of the sort to come to the conclusion that you could have an action as constituted in the Cameron case. Wrongly come to that conclusion. And so it was obviously necessary for the Supreme Court to deal with injunction cases. And the result of the case, of the judgment, is that the injunction cases do not permit you to constitute the action as the claimant attempted to do in Cameron. Of course, it does not follow, the reverse does not follow, that because you can't do what the claimant attempted in Cameron, you can't do the injunctions either. That's reasoning backwards. All that Cameron is authority for is that the court will not grant a judgment against a defendant if that defendant cannot be served. And provided there is a mechanism for service, provided it is not conceptually impossible to ever imagine that service is going to be achieved, then Cameron isn't a problem. So if Gamble is right, and I know this Court of Appeal has no say in that matter, then there is an appropriate method of service in the Wolverhampton injunction, and therefore Cameron does not stand in our way.
Well, you say we don't have any say in whether Gamble is right. If Gamble is inconsistent with that Canada Goose, we do.
Yes, Gamble came first, of course.
Well, I mean, inconsistent is what I said. If Canada Goose has failed improperly to follow its per incuriam, as we might say if we were permitted to use Latin, is decided without proper regard to Cameron. Gamble. Then we do have a say.
Yes, I mean, another way of looking at it was that although reservations have been expressed today in this court about the reliability of any distinction between protesters and trespassers, it's perfectly possible that the Court of Appeal in Canada Goose did think that there was a real difference, and really did not think that it was even trespassing, no joke intended, on the principles of Gamble.
Or Bromley.
But even supposing that that is right, and the Court of Appeal were considering protesters, there are protesters who protest on other people's land.
Yes.
So, unless you say that Canada Goose should be confined to people protesting on the highway, you've still got the problem, Jim, of those who protest on the highway, which they're entitled to do within limits, and those who wish to enter private land, as in Hampshire Waste, to conduct the process. So simply saying, oh, well, protesters are in one box and trespassers are in another, may be rather oversimplified.
Yes, it doesn't do it. It doesn't work. I accept that. And when I come to Canada Goose in a moment, I'm going to address that point head on, because my submission will be that if the claimant in Canada Goose had confined itself to the tort of trespass and had sued only people who'd gone into the shop where they knew that they were not welcome, then they probably wouldn't have had a problem. Now, I think the court has the point that Mr. Giffen made, that Cameron did not work in the Ineos case for the named defendant, and it was not read, despite the passage that Lord Justice Lewison drew attention to this morning, where his lordship, Lord Sumption, paragraph 17, says that the fundamental principle is, or the service problem is a more serious problem than the courts have recognised. It's certainly in Ineos, this court did not consider that his lordship was criticising Bloomsbury Publishing in any way. Before coming to Canada Goose, I'll deal briefly with Bromley, although I sense that the court has a pretty good idea about what went on in Bromley. But to begin with, this was a test case. The court intended to resolve some difficulties that had arisen from traveller injunctions. In paragraph 1, Lord Justice Coulson says that in terms. And there were interveners, including Liberty, and an impressive cast list of counsel. If we go to paragraphs, I'm just going to take you through the parts of the judgment I would invite your attention to. Paragraph 19. The claim in that case, the cause of action in that case was trespass. Paragraph 20, the Deputy Judge at first instance concluded that it was impossible to name the persons who were likely to commit the conduct which it was sought to restrain. She was satisfied that notice of the injunction could be given to those affected by it. And she concluded that there was a strong probability that unless restrained by an injunction, the defendants would act in breach of the appellant's rights. 23, his lordship then lists the 7 factors which caused her, the deputy judge, to refuse the relief being sought. The wide extent of the relief, it was not aimed specifically at antisocial or criminal behaviour, just entry and occupation, availability of alternative sites, cumulative effect of all of these injunctions, the failure to carry out an equality impact assessment, the duration, 5 years, and a planning issue that hadn't been properly addressed and certainly not resolved. At paragraph 32, there begins a passage of 3 paragraphs, 32 to 34, which deals with the fundamental principle. It shows that this court had the fundamental principle firmly in mind when deciding this case, 32, 33 and 34, repay being read. And 34, of course, makes clear that his lordship was talking about final injunctions, not just interim ones. At 39, or at 38, his lordship lists some of the cases which had caused difficulties or contention, and these were the cases listed in 38, which he referred to in paragraph 1, the problems of which he was seeking to resolve. But in the case of the Wolverhampton injunction, the same order that is before your lordship today, at letter B on page 351, he quotes fairly extensively from Mrs. Justice Jeffords' judgment.
Sorry, which paragraph?
This is 39B on our page 351.
Sorry, letter B. Yes.
So was the Court of Appeal in Bromley referred to the Gamble case? It's not listed in paragraph 38. I suppose it's because paragraph 38 is listing cases in which wide injunctions were obtained.
I imagine perhaps the Gamble case didn't feature in any of the arguments.
Doesn't look like it, does it?
There are two Gamble cases, of course. There's the South Cambridgeshire case, in which this court granted the injunction, which I haven't taken the court to,
Yeah.
and wasn't going to, unless we think we need to. And then there's the Gamble case I have cited, which is the contempt application.
Yeah.
So I can make the point and do that His Lordship cites at length from Mrs. Justice Jeffords' judgment. And then at paragraph 40, there begins a section where he specifically considers the Article 8 and the Gypsy and Traveller community issues, saying that the starting point is South Bucks and Porter. And he takes some care to cite authorities that not only nod to the problems experienced by those communities, the Gypsy and Traveller communities, but which spell them out explicitly. In particular, the section of the quotation from Lord Bingham's judgment, who in turn is quoting Mr. Justice Sedley on page 353, setting out the history of the problems that these communities have suffered with legislation which has denied them their usual stopping places. So the judgment is with a clear regard, obviously, to those problems. He then cites from Porter, and then we can, I think, go forward to paragraph 70. That's just another thumbs up, as it were, for the Wolverhampton injunction, where it was an important safety valve that there is going to be a transit site. Paragraph 99.
So how was the Wolverhampton injunction before the court?
It wasn't.
It wasn't.
It was
It's
merely
just an example.
cited as an example
I see.
of how you can do it if you take more care. And at paragraph 99, there begins a section entitled Wider Guidance. And his lordship here grapples with exactly the same considerations that Mr. Justice Nicklin has again grappled with in this case, and I of course make no criticism, but which the court advocates in the court, at Mr. Justice Nicklin's invitation, or the invitation of his judgment, is also grappling with in his skeleton argument towards the end. That these considerations have already been addressed extensively by this court in this passage. I'm not going to read it all out now, but I will draw your attention to paragraph 104, where in agreement, or
104.
104A, page 366, there are three particular considerations, although he lists 5. And the first of which is that injunctions against persons unknown are exceptional measures because they tend to avoid the protections of adversarial litigation and Article 6. So that point is firmly in the court's mind, and must have been firmly in the court's mind when this injunction, Wolverhampton's injunction, was reviewed and said by Mr. Justice Martin Spencer to comply with these guidelines. Paragraph 105, the Wolverhampton case gets another mention, being approved because the injunction didn't cover all the sites. Didn't cover the whole borough, only some of it. And in paragraph 106, again, Wolverhampton receives approval because of the duration of the injunction. So it's impossible to submit or to conclude that the Court of Appeal did not have in mind that the Wolverhampton injunction was a final injunction. Its duration is actually specifically approved in paragraph 106. And yet, all that the judge could say to all of this is to be found in paragraph 180 of the judgment. Insofar as any support can be found in Bromley for the contention that traveller injunction granted by final order can bind newcomers, the simple point is the Court of Appeal was not in that case considering the point that I have to decide. We say that the Court of Appeal was obviously considering this point. It was considering the circumstances in which such injunctions should and should not be granted. And those circumstances are already much more restrictive than before Bromley was ever thought to be the case. Indeed, Mr. Justice Nicklin, in the course of the litigation below, made clear that he considered that because of the Bromley decision, all of the cohort authorities were under a duty to bring their injunctions back before the court to see if they complied with Bromley. And yet, when they did that, when they were finally, as he would have it, dragged to court, the answer was, well, none of them did, because Bromley didn't have this point in mind, and these injunctions can't stand. And that's despite the fact that at paragraph 108, Lord Justice Coulson rejects the written submissions on behalf of one of the interveners to the general effect that this kind of injunction should never be granted. And Mr. Justice Nicklin has now accepted that submission from, I think, the same intervener.
So just say that again. 108
Yes.
in
Bromley. So it may not be the same intervener. I may be. It's Justice or Liberty. It doesn't matter who it's from.
which paragraph of Nicklin?
I'm so sorry, my lord. I was distracted for a moment.
Which paragraph of Mr. Justice Nicklin are we talking about?
180.
Okay, I think I'm slightly at cross purposes. So 108 of
180.
180 of Mr. Justice Nicklin.
Yes. What 180 of Mr. Justice Nicklin? It's dealt with in one sentence.
Yeah. Right, and you say that is inconsistent with...
Well, it's wrong. Paragraph 180 is wrong to say that the Court of Appeal did not have in mind the issue of whether final injunctions can bind newcomers. The judge, the deputy judge at first instance, had actually granted a fly tipping injunction, which was not the subject of an appeal, but was obviously a final injunction against newcomers. And as I say in paragraph 34, the judge said that the guidelines and the safeguards were particularly necessary in the case of final injunctions. given the nature of the injunction, it was bound to apply to newcomers. So in Bromley, the court is dealing with newcomers, is dealing with a final order, specifically takes into account the need for the Porter assessment insofar as it can be undertaken at that stage. Therefore takes into account the defendant's convention rights, has firmly in mind the fundamental principle, and prescribes a method for making sure it isn't breached, approves an injunction of Wolverhampton's which does just that by the duration of its terms and by the reviews and by the ability for somebody to set it aside on application. And all of that has been cast aside with the one sentence in paragraph 190. Of course, if the judge at first instance in Bromley had granted the injunction being sought, then presumably it would have been one of the ones before Mr. Justice Nicklin and would have been discharged, not for the reasons that the deputy judge had given for refusing it, but for this new reason. So we submit that the decision below is an attack on the settled law. I accept its oversight, but it was intended to settle the problems that arise in these cases. And this decision is an attack on that attempt at settling those issues.
And you say Bromley is inconsistent with Canada Goose?
Well, I'm going to try and distinguish Canada Goose.
But if Canada Goose is applicable to persons unknown traveller cases,
yes, then
it's inconsistent.
Yes, but of course the trouble for me with that proposition is that Bromley is overturned.
Why is it overturned? Because
it was an appeal against the refusal of an injunction on the merits.
The decision in the case was that the deputy judge was entitled to refuse the order.
Yes.
For the reasons which she gave.
Yes.
So it doesn't say one way or the other whether there were other reasons which would have precluded the grant of the injunction. All the court actually decided was that she hadn't taken anything irrelevant into account, and that as a matter of the exercise of her discretion, she was entitled to come to the view that she did. That's
right. But if one's looking at what this court was attempting to do in Bromley, it was attempting to settle these issues.
Well, that's the point I was going to make to you, Mr. Anderson. The point is it not, that this was a test case?
Yes.
That had been brought before this court in order to resolve, and I use that word advisedly, troubling issues affecting traveller injunctions.
Yes.
Now, how can you then say, well, what it said in trying to resolve that after heavy intervener submissions can then be ignored the next day by another division of the court, astonishingly containing one of the same members?
Well, my principal submission before, prompted by the discussion today, would be that one simply has to distinguish Canada Goose. But yes, if I can't distinguish Canada Goose, then Canada Goose has to be wrong. We've always made clear.
It has to be wrong doesn't help you either.
No, it doesn't.
But
Canada
Goose has to have been decided without proper regard to Bromley.
Yes.
I mean, actually without proper regard to Bromley, Gamel, Cameron, and maybe some other cases. Ineos.
Yes. And I'm going to come on to Canada Goose now, because it was an exceptionally weak case where everything that could be wrong with the claimant's case was wrong with it. Despite the fact that the protests had been going on for a long time, no attempt had been made to serve any individual with the order, even though the same people were turning up outside the store on a frequent basis. Well, rather than me recite it to you, let me take you to the judgment. Before I embark too enthusiastically on what was wrong with the case, can we go to paragraph 93 of the Court of Appeal's judgment, just to have a look at what reasons the court gave for refusing summary judgment. So, in this section, the court is dealing with the final order against persons unknown that was being sought by way of summary judgment. But it had already, by this stage, decided that the interim injunction, which had been granted by Mr. Justice Tier and continued by a deputy, should also be discharged. And Mr. Justice Nicklin, the judge at first instance, had discharged it as being inappropriately worded. And I'm going to have to take the court to that judgment in a moment. But having decided that the interim injunction shouldn't have been made, the court, having agreed with Mr. Justice Nicklin, the Court of Appeal then goes on to deal with the application for summary judgment for a final injunction. And one may think that by this stage, the prospects were not very good. And indeed, we learn in paragraph 94 that some of the problems that beset the interim injunction were also still a reason. There were still problems with the injunction in the form before the court for which summary judgment was being sought. So those problems, that the injunction was too widely worded, were still problems. But the court does give in paragraph 93 an additional reason for refusing summary judgment. And the court tell us in explicit terms what Canada Goose's problem is. Its problem is that it's seeking to invoke the civil jurisdiction of the courts as a means of permanently controlling ongoing public demonstrations by a continually fluctuating body of protesters. It wishes to use remedies in private litigation, in effect to prevent what it sees as public disorder. Private law remedies are not well suited to such a task. As the present case shows, what are appropriate permanent controls on such demonstrations involve complex considerations of private rights, civil liberties, public expectations, and local authority policies. Those affected are not confined to Canada Goose, its customers and suppliers and protesters. They include, most graphically in the case of an exclusion zone, the impact on neighbouring properties and businesses, local residents, workers, and shoppers. One can see in those words the particular considerations that apply to the particular protest that was going on in that particular case. This was in central London, in a busy shopping street. And there were competing considerations of the sort discussed. We also have the problem in protester cases that the right to protest is a convention right in itself. The right to engage in public protest, an important aspect of the freedom of expression and of peaceful assembly, protected by Articles 10 and 11.
Could you just help me on this paragraph 93, where the court talks about effect on other people, neighbouring properties, businesses, local residents, workers and shoppers. We're talking about Regent Street.
Yes.
The effect on all those people, one might have thought, would support the grant of injunction rather than work against it
Well, no, because if only, I mean, the injunction was quite an extraordinary beast. It prescribed a number of protesters that were allowed to be within a certain distance of the shop. So the problem was that that line would be drawn, and then just the other side of that line, there would be a whole bunch of protesters bothering the people down the road. That was just one of the problems. So, as I say, these people in Canada Goose were themselves exercising protected rights. And so the court had to be satisfied, if it was to enjoin them, that it was necessary in a democratic society for the achievement of one of the aims set out in Articles 10 and 11.
And Section 12.3 had to be satisfied.
Yes, it is. Now, the Court of Appeal, in this case, in short, decided that where those articles are engaged, that isn't something you can do in advance. That's why, because the civil law is a very blunt instrument and is not suited to that particular task. It was not a decision that you can't carry out in advance the balancing exercise envisaged in Porter as interpreted in Gamble, applying to persons unknown, which engage different convention rights. In Gamble is authority for the proposition that you can perform the balancing task in advance in cases engaging Article 8.
So why can't you do it in advance? It was done in advance in Ineos and in Hampshire Waste.
Well, it was only done pro tem.
Well, yes, certainly.
Well,
But
that's an important distinction in protester cases. That,
right, so we're now back to the distinction between interim and final orders.
yes, but it's one that absolutely exists in protester cases, and by which I mean not cases that are merely about protest, but cases that engage Articles 10 and 11. And of course one can see that in such cases, in the Canada Goose case itself, if we go to the beginning of the Court of Appeal's judgment, paragraph 7 on page 395. The demonstrations have been largely small in scale, with up to 20 people attending, and generally peaceful in nature. Paragraph 8. A minority of protesters have committed unlawful acts. And the injunction that was granted is a paragraph 12. And it gets worse as it goes on. And I would invite the court to read paragraphs 12, 13 and 14 on page 397. Now, in fairness, I have to make clear that even this interim injunction was discharged. And it appears that the court considered that what it said about this case, Canada Goose case, it intended to apply to the Ineos scenario as well. And in Ineos, the injunction didn't share these defects. It was a much, after it had been to the Court of Appeal, was a well-tailored injunction that relied on the cause of action of trespass and interference with a nuisance to rights of way. But if one looks at the injunction that has been granted, one considers the circumstances of the case where this was a precautionary injunction in the sense that it was looking to prohibit conduct tomorrow, which hadn't yet happened. But it was very different from the source precautionary injunction that Wolverhampton has obtained in important ways. It was an application for summary judgment to stymie an existing activity. These protests were ongoing. It wasn't intended to hold the ring. There obviously was never going to be a review of the injunction. As I say, it was an application for a final summary judgment with nothing provisional about it. And it sought a blanket ban on vociferous protest. And when one bears in mind those considerations, and then comes back to paragraph 93 where we started, one can understand why his lordship said what he said. And one can understand that it may well be a very real distinction between that sort of case and the Wolverhampton case, where there is a much clearer binary distinction between trespass and not trespass, where there is no difficulty in deciding, subject to convention rights, whether an injunction should be granted, where the activity is always unlawful, and where there is no assessment to be undertaken, where there is no risk that the injunction will bite on people who are merely standing outside a shop. None of those risks apply. So we do say that this case is distinguishable. It's a very different type of injunction issued in a very different scenario. And one can see why the court thought that Cameron was of significance in a case like this. Because in this case, the claimant had deliberately taken the decision not to serve any of the 130 odd people whom it had managed to identify. And it told the judge at first instance that it had taken that decision out of proportionality because it didn't think it was fair to sue so many people.
You say there's a binary distinction between trespass and not trespass, which means there's a binary distinction between lawful and not lawful. If somebody is on another person's land without consent, but requires the porter balancing exercise to be undertaken on the ground that they have Article 8 rights, and suppose that the balance comes out in their favour, does that mean that what they are doing is lawful, or simply that the court will not grant a remedy for unlawful conduct?
The latter.
The latter.
Yes.
It's still tortious.
Yes.
Presumably also means the court won't award damages? Or does it? Maybe it does.
I don't know the answer.
Maybe it awards monetary recompense for being on the land. I don't know. What do you say?
I don't know, I'm afraid. I can think about that if it's important, but my initial reaction would be to say that it would be difficult to see an answer to a claim for mean profits in such a case. So we would distinguish Canada Goose in any event. Can I finish by a few observations about the judge's approach to what he called contra mundum orders, universal orders intended to be of universal application. It is true that the cases which deal with such orders tend to emphasise that they must only be sparingly issued. That's the law. We take no issue with that, and it's not far different from what was said in Bromley about these sorts of cases. But it can't be the obvious reason why the cases, the publication cases, say that these injunctions must be sparingly and almost never issued, is because the right to publish is being restrained. And specifically, usually, newspapers are being prevented from telling their readers about criminals, people who've done wrong. And it's not surprising that in those cases the courts emphasise the need to exercise very great caution before issuing such injunctions. But that absolutely provides no principled reason for Mr. Justice Nicklin's decision in this case. There is authority that if somebody is in possession of private photographs, the publication of which would infringe human rights of the person depicted in the photograph, then an injunction preventing publication can go. Why assume that you cannot ever have such an injunction in a case where people of Wolverhampton are being denied access to their open spaces, are having to suffer the sort of activity graphically described in Mrs. Justice Jeffords' judgment? It may be that sometimes the conduct isn't sufficiently serious to warrant such an injunction. It may be that sometimes the claimant is making the mistake of including everybody when there are only some small number of wrongdoers. But those are all considerations that can be taken into account at the adjudication stage. So we would submit that the Bromley guidance should stand. It's already very draconian against local authorities, and if properly applied, will have a dramatic effect on the ability of local authorities to obtain these injunctions. And we, therefore, say there was absolutely no reason for Mr. Justice Nicklin to revisit the whole question and to say that such injunctions, as a matter of principle, can never be issued.
And is that what you said to him?
Yes. It's all been settled by Bromley.
And where did he say it wasn't?
He said in paragraph 180 was the
He said Bromley wasn't considering what I had.
yeah.
Just that.
Well, I'll double check after court tonight, but that is my answer at the moment. Yes, and I believe it to be true.
Yeah, I'm not suggesting it's not true, but then when I search Bromley, I find 48 references to Bromley.
108. 180.
180.
Oh, sorry, I thought you were telling me. Yeah. Those are our submissions.
Right. Thank you, Mr. Anderson. Right, Mr. Bowes.
My Lord, as my friend Mr. Giffin indicated this morning, I have ceded the majority of my time because I recognise that the issues upon which my friends Mr. Giffin and Mr. Anderson are the central ones for the court, including the grounds for distinguishing Canada Goose and Cameron, and therefore require the majority of the time. I therefore will be speaking for just some 30 minutes, and I'm going to deal with two discrete issues. And the first is whether Section 187B itself envisages that final injunctions may properly be sought and granted against newcomers. The judge held that it did not, and he said that the procedural rules that apply, namely Practice Direction 20.4, appear positively to rule out commencing proceedings against persons unknown cannot be identified by the means required by that practice direction. And this is, we submit, the first occasion this issue has been considered by this court. In Canada Goose, Section 187B was clearly not an issue, as my Lord Justice Lewison has noted, was the planning case. Section 187B was referred to by Lord Sumption in Cameron at paragraph 9, but solely in the context of being a specific statutory exception to suing persons unknown. And as my friend Mr. Anderson has indicated, this court in Gamble, certainly the logic of the reasoning would support such injunctive relief, but it didn't actually say as much. So it is the first occasion. There are...
187 is engaged here, is it? 187.
My Lord, it is.
Yeah.
In the circumstances of unlawful residential occupation of public spaces without planning permission. My Lord, there have been cases in the High Court, non-traveller cases, where the courts have assumed that final injunctions have been granted, and we refer to 3 of those in our skeleton argument, paragraph 86. But the points weren't argued there, and therefore I don't take my Lord to them unless you wish me to, for context.
Right, and the judge said that the rules didn't allow a final injunction under 187 against persons unknown, but did allow an interim injunction.
It didn't actually say that, no.
Which para?
It's paragraph 176.
Well, he said you hadn't complied with the practice direction.
That's correct.
For identifying, he said, if you want to rely on 187B, you've got to comply with the practice
That's
direction.
right.
And you didn't.
Because the practice direction doesn't contemplate cases where you are in effect...
Well, you couldn't identify the people that you wanted to sue by any of the methods that the practice direction said you
My
should
Lord,
use.
that's right. That's correct. That's what he said. And the advocate has identified 3 questions on this issue, which we agree with. The first is whether the section envisages that final injunctions may be sought against newcomers. The second is, if it does it require there to be appropriate rules of court permitting such claims? And thirdly, if it does, are there such rules? And our submissions are that the court should answer all these 3 questions in the affirmative. What I propose to do, my Lord, is to go first the section and make some points about its language, and then deal with questions of mischief on the first question. My Lord, section 187B is in authorities bundle
What do you
B.
say about the judge's point that you hadn't complied with 20.4 by providing a photograph, a thing belonging to or in possession of the defendant or any other evidence?
My Lord, our submission is that if, on a proper construction of the section, Parliament did envisage that final injunctions could be granted against newcomers, then self-evidently these were persons who could not be served in advance by means of alternative service. Therefore, there would have to be that category of person where the court dispensed with service altogether. And Practice Direction 20.4 does in 20.4 provide for identification of persons by reference to various things, but then immediately thereafter notes in parentheses that the court has power to dispense with service under Rule 6.16. And so the Practice Direction expressly contemplates cases where, in seeking such relief, dispensation with service may be permissible. And as trial judge here, Mr. Justice Nicklin, has held in another case, Winch, in the divisional court, where contramundum injunctions are sought, those are the exceptional kinds of case where the court will grant dispensation of service under Order 616. And we say that logic is the same here. If 187B contemplates such injunctions against newcomers, logically there has to be dispensation with service. The answer is 6.16, and that itself is referred to in the Practice Direction, to which the judge didn't...
Well, there has to be dispensation with service before grant of injunction,
My Lord, that's right.
and procedures afterwards for ensuring that any person affected can vindicate their
Yes,
arguments.
absolutely. But those procedures are ones which, for all the reasons that others have given, can be and are built in habitually to such injunctions, including the power to set aside or vary.
Yeah.
So if I can go first the section, it's Authorities Bundle B, Section A, Tab 7, page 22. And my lord, I won't.
We've also got it as an appendix to the judgment on page 116.
My lord, yes. Maybe that would have been easier than giving out a large number of letters and numbers. And Lord, if I may just read the section first and then make 6 points about it. Provides that where a local planning authority consider it necessary or expedient for any actual apprehended breach of planning control to be restrained by injunction, they may apply to the court for an injunction whether or not they've exercised or are proposing to exercise any of their other powers under this part. 2. On an application under subsection 1, the court may grant such an injunction as the court thinks appropriate for the purpose of restraining the breach. 3. Rules of court may provide for such an injunction to be issued against a person whose identity is unknown. And then subsection 4, court includes the county court. Lord, the section we say is in designedly broad terms. Firstly, it is concerned with land. That is clear from the definition of planning control, which my lord doesn't have in the bundle, but we can provide if need be, which is the carrying out of development without the required planning permission, and then development by the Act is effectively defined as the carrying out of operations in, on, over or under land, or the making of any material change in the use of any buildings or other land. So the focus of planning and planning control is on what is done onto the land. It's a focused provision. And the identity of those who may do the prohibited acts to the land is really a secondary consideration. What the section is about is protecting the land from unlawful development by anyone. Now, the second point is that the section enables an authority to apply to court in relation to any actual or apprehended breach. So expressly, relief is available where the breach has not yet happened. And alone amongst planning enforcement measures, it provides a prospective remedy. Parliament clearly considered that prevention is better than cure, and experience bears that out, because as soon as people are on land undertaking works in breach of planning control, then even where enforcement notices or stop notices are served, there then can be appeals, habitually are, much harder then to get people off the land, and the risks of damage to the land and costs increase. So specifically provides where the breach is threatened. The third point, my lord, is as one sees from the last part of subsection 1, it's available whether or not the authority have exercised or are proposing to exercise any of their other powers. So it is a standalone remedy which may be used in preference to others. It is not simply a backup. And of course, if one seeks an injunction to restrain an apprehended breach of control, and that injunction is granted, i.e. on a provisional basis, prospective basis, then you will never have a breach. So it is the remedy. Lord, the fourth point is, as subsection 2 makes clear, the power for the court comes from the section itself. There is no need to rely upon section 37 of the 1981 Act. And the subsection 2 speaks only of an injunction. Certainly the draftsman saw no reason to distinguish between interlocutory or final, as one does see in section 37. All that the draftsman, all that Parliament were concerned about was the grant of an injunction that is appropriate in the particular circumstances. And that brings on to the fifth point. The court's powers are to grant an injunction as it thinks appropriate. That is a broad discretion, clearly to be exercised in accordance with principle. And there is certainly authority, my lord, that the language doesn't add or subtract from the criteria in section 37 of just and convenient. If I could just give my lord the note. That's Lord Scott's speech in Porter at Authorities, tab C, tab 32, paragraph 98. My Lord, the final point about the section on its plain meaning is that subsection 3 expressly contemplates that the court's power is exercisable in relation to a person whose identity is unknown. And it is likely, we say, that this was designed specifically to address cases of apprehended breach, because overall, by definition, it will be at that stage that it's most difficult to identify those who may be threatening to commit the breach in question. So, my Lord, that is 187b. We submit it is a broad, open-textured section, and there is certainly nothing on a literal construction of it that would exclude the availability of relief against, final relief against newcomers.
So you read subsection 3 when it says rules of court may provide for such an injunction to be issued as, well, it's talking about the injunction being issued, not the proceedings being issued. So that, you say, refers to the order.
Well,
Do you?
no, well, no, I mean, the wording is or, to be issued, because it's correct that in subsection 2 there is a reference to an application. But certainly how it has been interpreted by the Rules Committee is that the rules are concerned with how proceedings are to be issued, namely paragraph 24 of the practice direction.
Yeah, but the section talks about not proceedings being issued, but the injunction being issued.
Well, my Lord, if that's right, there is no practice direction that deals with that. The only practice direction deals with the application being issued, and that's 20.4. And I say that's how one reads this.
Common parlance, one talks about injunctions being issued, but courts and lawyers don't.
Yes.
So it looks as if the parliamentary draftsman nodded between sub 2 and sub 3.
If that's wrong, then there's a big difficulty because there's no practice direction even for obtaining injunctions against any person that you can identify by photograph or anything else.
But do you say that the bit about the photograph qualifies the rule allowing orders to be made against persons whose identity is unknown?
I say that it does, but because within the practice direction there's also the provision about 616, and it has to come down to whether or not I'm right that as a matter of construction Parliament intended this section to have the breadth that we say it did. And for that, may I then go to issues of mischief? And, my Lord, the first point to make is that it appears to have been judicially recognised since the 1960s that the nature of gypsy and traveller encampments on land by a floating population make it impossible for legal owners to take effective steps to prevent such unlawful uses of land by use of injunctions. By virtue of the changing identities, even if one can obtain names, there will be others who fill the place and make it nigh impossible to obtain effective enforcement. And that point was made by the Lord Chief Justice in a case called Tanner, which, if I may take my Lord to extremely briefly.
What was the name of the case?
Test Valley and Tanner, my Lord. It's Authorities Bundle B, Section C, Tab 11, and it's page 287. Tanner was an appeal by way of case stated from the conviction of a landowner under the 1960 Caravan Sites and Control and Development Act, on whose land a floating population of gypsies had encamped. The authority brought a criminal prosecution against the owner on the grounds that their inaction meant they had caused or permitted use as a licensed caravan site. And there was then an appeal by a case stated, and the Divisional Court allowed the appeal. And this was on the basis that the only possible steps which would have been effective would have been physical ejectment, which would have been unreasonable in the circumstances. And if I can ask my Lord to go to page 288 of the bundle, and it's the judgment of Lord Parker, Lord Chief Justice. And he notes in the middle of the page, on or about December 20, 1961, a number of gypsies saw this vacant site and went thereon with their caravans, their horses, and their tents. They made a camp, constructed rough shelters, and in fact used the land as an encampment. And that has continued up to this day. Not always the same gypsies there, naturally, but a floating population of gypsies, caravans, tents, and all their paraphernalia. Towards the bottom of the page, the Lord Chief Justice refers to the steps that the owner took, and about 5 lines down from the last paragraph, on August 17, he instructed solicitors and proceedings were commenced. As I've said, this is a floating population occupying the site. It's quite clear that even when the names of the particular occupants were discovered, it was really impossible to take effective steps, and indeed, if a person against whom an injunction had been obtained was still there, the appellants in fact took no steps to enforce the injunction. And then, just over on page 289, the 4th line down towards the right, indeed, it was recognised by everybody that the county court proceedings were really ineffective to deal with this floating population. So, Lord, this was early recognition of the particular problem posed by some members of the gypsy community in the context of planning law and planning enforcement. And that same point about the difficulties posed by a floating population was made some 12 years later again by Lord Widgery, Lord Chief Justice, in another case called Carthy, which I could just give my Lord the note for this. It's the same point, I won't take my Lord to it. It's tab 13 at page 317, where in effect, Lord Chief Justice said it's no good bringing proceedings against a floating population. So, Lord, this issue, this difficulty, has long standing, and is not something which has gone away. As my Lord would have seen from the submissions made by the intervener Basildon Council, it currently has a case called Anderson, where there have been trips to the High Court and the Court of Appeal, where deliberate breaches of planning control resulted in a planned invasion of greenbelt land over the weekend by some 80 to 100 people with diggers' trucks dividing the land into plots, utter disregard for planning law and also for interim injunctions, and the needs for committal hearings and the like. And the point made by Basildon, I'm sure my Lord will read the submissions after the hearing again, is that at the moment Basildon has an interim injunction, but incursions have still continued, new people have still come. And if the judge in our case is correct, then as soon as Basildon obtains its final injunction, there will be impunity for any newcomers then to act, and Basildon will have to go to court again. So this is a common problem that is long-standing. So that's part of the mischief. The precise reason for section 187B was the consideration that in the 1980s, the planning system had in effect been systematically abused. And for that proposition, may I take you please to the South Buxton Porter case, which is tab 32 of the authorities bundle. And it's the speech of Lord Steyn at page 894. And as my Lord has already been indicated by others, the issue in Porter, there were named defendants, it was a 187B case, and the principal issue was whether 187B conferred an original jurisdiction of the court or a supervisory jurisdiction, and the court held, contrary to local authorities' arguments, it was the former. And in paragraph 45, Lord Steyn speaks about the setting of 187B. By the 1980s, it had become a notorious fact that determined individuals and enterprises could, by playing the system with the aid of lawyers, frustrate the implementation of valid planning decisions for many years. It was not only old sleeping caravans which caused the problem, more frequently fragrant and persistent breaches were perpetrated by entrepreneurs for commercial profit. Goes on to say, the 1990 Act, TCPA, also contained provisions that serve as stop notices, and they were supported by the power of the Attorney General and Section 222. Then just below D, there was nonetheless a strong perception the planning system was systematically abused and that it required more effective enforcement. And that was the context for Mr. Carnworth, Queen's Counsel, to be asked to produce his report. And he reported one sees paragraph 46, part of his report. Paragraph 10.3 described the supplemental function of injunctions. And Mr. Calmer said, I think it would be a mistake to attempt to prescribe too closely the circumstances in which the remedy would be available or the forms of order which could be granted. Experience of decisions over the last few years shows that the merit of the remedy is its flexibility and its ability to evolve to meet changing needs. Well, that was the context of section 187B. And then may I finally go right at the end of bundle B, at bundle B, section D, tab 3, page 2301, to the second reading of the Planning and Compensation Bill in the House of Commons.
So is this a passage from Hansard?
It is, my lady, yes.
How is it admissible?
It's admissible, my lady, not on the grounds of going as to the mischief, although we've included within the authorities a section from Benyon which states and provides authority for proposition that it's permissible to refer to parliamentary debates, not under the rule in Pepper and Hart to resolve ambiguity, but as part of enacting history, including to show the mischief for which a provision was aimed. And it's literally a couple of sentences I wish to refer to. My Lord, page 2299. So I gave the wrong page, I apologise. 2299, and it's the Minister for Housing and Planning, Sir George Young, introducing the second reading. And he says at the foot of the page, many honourable members are rightly exasperated at the ease at which people can flout planning controls and get away with it. The present enforcement systems are rightly criticised for their complexity and slow operation. That reduces public confidence in the development control system and appears to penalise those who comply. He says clauses 1 to 11 and section 187B was added by section 3, then clause 3 contain important measures to strengthen, improve, simplify and speed up the enforcement process. Sir George then took an intervention from Sir Peter Horden, the member for Horsham.
Sorry, I haven't found this page. What page is it?
My Lord, it's 2299.
In which? In the bundle or in the electronic bundle?
I'm hoping in both, my Lord.
Certainly not both.
Oh.
They're miles away from one another. But I've got 2299 in the electronic, what's printed on the page, but it's not what you're reading.
Well, I'm told if one adds 8. I'm sorry, I've been working purely on...
I'm looking at the paper page numbers. And does it say 3, what's the time above this passage?
3:57 p.m. It's the first page in that excerpt from Hansard.
Yeah, okay.
So I've got letters page 2299, 357.
Okay, thank you.
And so, my Lord...
But you started reading halfway through that passage.
What are you getting out of this, Mr. Post? Just in a sentence.
It's simply that there's an exchange with Mr. Horden, and Sir George Young specifically refers to clauses 2 and 3 and says that may help with the power problem you've described. That is the power, the provision in relation to gypsies. And he says the power to take an injunction against persons unknown would be especially helpful in dealing with gypsies. Right. That's the sole point, my Lord. It's has a very large.
Do we actually need it? Because isn't it obvious that that's one of the reasons why section 187B was enacted?
Well, my lady, given my submission so far, no, but I thought it useful to take one to court in the event to make that point clear. And we submit, in the light of the wording of the section and the mischief, that Parliament should be taken to have intended that final injunctive relief could be sought and made against a newcomer for 3 reasons. Firstly, this was a well-known problem of a floating population of the gypsy community in the context of planning non-compliance. Secondly, Parliament's concern was clearly that planning law had been abused and needed strengthening. And thirdly, subsection 3 expressly contemplates proceedings being brought against persons whose identities are not known. And if we are wrong on that, then the result is, we submit, that Parliament was providing a specific remedy to meet a well-established problem, which was fundamentally flawed because it didn't adequately address the question of the floating population or the ongoing risks to unlawful development of land.
Is there any previous authority since this was enacted that says it can't be used to deal with cases against persons unknown?
No.
There's no authority either way.
No. Well, there's no. I mean, it is being used. Certainly, there's High Court authority, as I indicated, where injunctions were non-traveller cases, where injunctions were made, and then committal applications were brought, and no point was taken about whether or not the injunction, in fact, bound the contemner.
Right, but is it widely used?
It is widely used. Yes.
Against persons unknown?
It is, my lord. I think that my friend Ms Bolton may be in a better position to answer that, given that she acts for a number of local authorities. And I think, my lord, also the submissions for Basildon demonstrate the use to which they put it, not for the borough-wide traveller cases, but for classic non-compliance with planning law.
Yeah.
Well, that's the first question. As the second one, we accept that there is a requirement for rules. But thirdly, we submit that there are rules there, and it is the power to dispense. I've already made my submission on that. Would my lord like me to take you to the practice direction and explain further my point?
We've seen it.
I'm grateful. So essentially, my lord, and the authority I referred to where Mr. Justice Nicklin spoke about dispensation in contra mundum cases being exceptional for Cameron. That's a case called the Winch, where Lord Justice Warby agreed. Again, just for my lord's note, that's Bundle B, Section C, tab 87, page 2145, paragraphs 31 and 29. Well, that's the submission under Section 187B. The other matter I propose to deal with briefly is what was described as Issue 5 in the letter sent to the court last week. And essentially, it's whether the judge erred in holding that in claims brought by local authorities to uphold public rights, a final injunction will only bind persons who are parties to the proceedings by the date of the final order. Well, this is a limited submission for the reasons I'll explain. But it arises in a context where the claims brought by each of the appellants here are not purely to enforce their own private rights. They are claims to enforce public rights enjoyed by their inhabitants who have a collective interest in them being upheld and who suffer collectively when their rights are infringed. We say that in this class of case, where the local authorities are litigating, they are in the same position as would the Attorney General have been had he been exercising his own common law powers to bring proceedings to restrain the commission of public wrongs. And there is Court of Appeal authority, to which I'll take the court in a moment, that where the Attorney General brings such proceedings, either on his own account or by way of a later action, the dispute is not one between individuals, it's between the public and a small section of the public who refuse to comply. And that if the court alone can provide a remedy, it should in general lend its aid to enforce obedience to the law. And building on that, we would submit that a similar approach applies where local authorities are litigating to protect public rights. The problems caused by persons unknown in this jurisdiction is a real and contemporary one, which harms communities and which cannot properly be dealt with save by the use of injunctive relief. The courts have developed in this area by the use of persons unknown injunctions, see Bloomsbury, see Hampshire Waste. But our position is the only way that injunctions in this area are effective is if the relief extends to newcomers. And we do say that the court should extend the law on a principled basis to permit that. Now, the big caveat, my lord, is that I accept that this issue arises only if the court is persuaded, principally by submissions by learned friends Mr. Giffen and Mr. Anderson, that it is not bound by Cameron and or Canada Goose, and also that there is some scope for an extension of the law or recognition that the law can grant final injunctions against newcomers.
But if that's the case, you don't need the argument.
Well, not, but the point is that the reason I make the submission is twofold, because if there is some scope, the point made by my learned friend, the advocate to the court, is that if we are right and there is jurisdictional power to make such injunctions, then that really collapses the jurisdiction into that of injunctions against the world, and therefore that's one reason why it can't be right.
But for this kind of injunction, what is the cause or causes of action on which you rely? I mean, there are some elements here of trespass where the local authority owns the land, but that you might say is private rights, albeit the local authority is enforcing its private rights for the benefit of its inhabitants. Some might be nuisance of one kind or another, maybe public nuisance, maybe private nuisance.
Well, there are three.
Do you distinguish between any of those things, or you just say, as long as the authority is acting under Section 222, that's all right?
No, I don't. In our case, has never been Section 222 as the answer. I accept entirely. Section 222 purely provides the locus for an authority to bring proceedings. We say there are three forms of public wrong. There's firstly breach of the criminal law itself, which in this case is the Town and Country Planning Act 1990, and Section 187B deals discreetly with that. The same principle applies. Secondly, there is public nuisance, and in principle here, the bringing onto open land of waste and fly tipping would or could, I accept, amount to public nuisance. And then, as my lord indicates, there is trespass in the way of occupying the land for residential purposes when that isn't permitted. Now, for the first two causes, Section 222 needs to be relied upon for locus. For trespass, I accept it doesn't. Local authorities are corporations, they are landowners. They're entitled to seek relief on their own account. But the reason why we seek to bring those trespass claims as public claims is because the land in question here is green space, parks, recreation grounds.
That's held under the Open Spaces Act.
Yes, some of it is held under the Open Space Act, others under trusts under the 1875 Act.
Right.
But it is all land which is held by local authorities, not as part of their administrative function, but for the public.
Just going back to the breach of criminal law, acting in breach of planning control is not a criminal offence, is it? Unless and until an enforcement notice has been served.
My lord, that's right, yes.
So what are the breaches of criminal law that you wish to rely on?
Well, no, we would, in this case, we'd say that we don't need to rely upon that, but it's under 187B, where the court has a similar power to enforce planning law in the public interest. And so there are indications in the case law that planning law is in fact there. I'll give my lord the reference. As it was said in I can't find the reference, but if I find it, but I hope my lord gets the point that it is on behalf of the public that planning law is enforced. And so we say that where an authority is seeking to enforce public rights, it stands in a similar position to the Attorney General, and that the courts should in general seek to assist the Attorney General when it seeks to enforce public rights, where the court can provide that remedy. And the authority for that is a case called Attorney General and Harris, which is at Bundle B, Section C, Tab 10, at page 264. And I go to that for three propositions before I take you to judgment by matter. Firstly, that the Attorney General brings proceedings in the public interest with the attorney representing the whole public. Secondly, the dispute is not between individuals, between the public and a section of individuals. And thirdly, in cases where under existing law the court alone can provide a remedy, it should in general lend its aid to enforce obedience to the law when invoked by the Attorney General. My Lord, this was a case concerning, it was a relator action on behalf of the Manchester Corporation, and it concerned a flower seller who was selling flowers from a stall in breach of an 1844 local act. And prosecutions were made, but he continued to do so, and accordingly the Manchester Corporation sought the Attorney General by way of relator action. And it allowed an appeal from the refusal by Mr. Justice Salmon to grant an injunction to restrain the flower seller. If I may go first to page 276.
I mean, this is miles away.
It is.
Case. What did the judge say about this argument?
Well, the authority was cited to the judge. He didn't refer to it.
Right.
Well, I accept. I mean, I've given the main points from the judgment. I don't need to take my lord anymore.
No, we don't need to read it all
No.
ceremoniously out. You've made your submission. You
Yep.
say this case supports it.
My lord, that's right. So well, that's that submission, if needed. Lord, can I end by just indicating some more general concerns of my clients, if I may? I'll be very brief. We recognise that these appeals are concerned with injunctions directed towards travellers. And we understand that the judge had a number of well-made concerns about that sort of injunction in this jurisdiction. But we say that the Court of Appeal in Bromley has dealt with those so as to ensure that only proportionate orders are made. But our concern is that the judge's judgment applies not only to traveller injunctions, but it applies also to all those other cases where local authorities have sought injunctive relief and been granted it to deal with a series of public nuisances affecting their localities, whether that be raves or other noise or commercial tipping or car cruising. And the effect of the judge's judgment, if correct, is that none of those claims can now be brought, leaving a very unfortunate lacuna in the law. May I take you lastly to a Court of Appeal decision post-dating Canada Goose called Sharif in Birmingham, which was a car cruising case, just for example of problems that will be caused. My Lord, it is Bundle B, Tab C, Section C, Tab 82. And it's a judgment of Lord Justice Bean, with whom the Master of the Rolls, who had, of course, been in the Constitution of Canada Goose, agreed.
Sorry to interrupt, Mr. Bowes. I haven't got tabs in my authority fund. Could you give me a
No,
page
right.
number?
My lady, it's tab 80, tab.
Haven't got tabs.
Haven't got
Oh,
tabs. So can I have a page number?
It's page 208.
2088, I'm grateful.
208.
Sorry.
Thank you very much.
And this was an appeal in 2020 to the Court of Appeal from a refusal in May of 1919 from His Honour Judge McKenna as a deputy to set aside a queer timid person unknown injunction that had been granted in 2016 for around 3 years to restrain car cruising within the local authority area. And if one goes to paragraph 1 on page 2089, one sees Lord Justice Bean setting out what car cruising is, a form of antisocial behaviour that has apparently become a widespread problem in the West Midlands. He refers there to an injunction being made in 2016 for 3 years, and then continued in 2019 by, first in 3 years, I think it was then later, that was a person unknown injunction. And
I'm sorry, I'm not sure I'm on the right page. What page is it?
page 2089, my lord,
208.
and that's paragraph 1 of Lord Justice Bean's judgment. And it refers to what car cruising
yes.
was, and then refers to there being an order made for 3 years in October 2016, and then Judge McKenna refusing an application by Mr. Sharif to discharge the injunction. And that had arisen because Mr. Sharif had been served with injunction sometime after it was made, as an application for his contempt was sought for breach of the injunction. And in those circumstances, he sought to discharge it. It was, on what seems in paragraph 3, the nature of the activities in question. And paragraph 5, a provision in Judge Worcester's order to enable anyone to discharge it. And then in 2018, paragraph 6, application to commit being made against Mr. Sharif. Then at page 25, paragraph 25, Lord Justice Bean sets out a test from Bovis about the guiding principles of the granting of injunctive relief, and the appeal against the refusal is dismissed by the court. Paragraph 42 on page 2101, Lord Justice Bean says this: Judge Worcester and Judge McKenna were well entitled to conclude, in the words of Lord Justice Bingham's third criterion in Bovis, the car cruise in the Birmingham area would continue unless and until effectively restrained by the law, and that nothing short of injunction be effective restraining. I regard this as a classic case for the grant of injunctions, person unknown injunction. And then finally, at paragraph 44, he notes that no point was taken in the court below about the grant of the injunction being made against persons unknown and the provision for service. He then refers to Canada Goose in the Court of Appeal, and he says at the end, it may have to be considered again in any future case about injunctions to restrain and social behaviour by persons unknown. I simply recall being told by Mr. Manning, persons unknown issue was the reason why Birmingham didn't apply for antisocial behaviour injunction. So this is the Court of Appeal in a post-Canada Goose where the Master of Rolls was himself present, not saying in terms, Canada Goose binds, leaving it open for another case, but more to the point, if the judge is correct here, this injunction was made without power. And that will be a problem for my clients and other clients and communities up and down the
It was a final injunction granted for 3 years and then renewed.
Yes. Yeah. And is therefore, on the judge below's judgment, unlawful. So Lord, that is our concern. And my friend Mr. Giffen has also indicated why even if the judge is correct, the prospect of getting any relief in any case is vanishingly small. Because if one says that one has to have trial defendants, one only has a period of 4 to 6 weeks to get them, then if the injunction is doing its job, if the interim injunction is doing its job, there'll be compliance. People can comply because it's there, because they know, or will know, that as soon as the final hearing is there, the injunction is set aside, they have impunity. So we do say the jurisdiction first brought from Hampshire, Waiting and Ineos has in effect, or will in effect, be swallowed up. Those are my submissions, my Lord.
Thank you very much. Well, I think we'll break there, Miss Bolton. You'd have 1 minute, but that's not enough even to poison our minds. So let's resume at 10:30 tomorrow.
My Lord, may I use that 1 minute?
It's already passed, but you may.
I'm here in respect of HS2.
Yes, I thought you weren't coming.
And I very much enjoyed the mornings and afternoons so far. But here with the permission of the Vice President,
Yes.
who indicated that he thought my oral contributions might not be required, but left it very much to the discretion of the court. So the door being left.
You want to make
ajar.
some?
Yes. So I would apply to make some short submissions of less than 10 minutes during the course of tomorrow, immediately after Miss Bolton has done so. So I thought I should raise that now.
Less than 10 minutes, I think we can.
Less than 10 minutes will
permit.
be very welcome.
We have very low boredom thresholds, but we can probably manage less than 10 minutes.
I'm so grateful.
Thank you.
My Lord and my Lady, would you mind just perhaps me addressing you on the timetable tomorrow? Because I understand that there may be some work done overnight on the question of precedence, and clearly my learned friend Mr. Jones and I and my team would need to have an opportunity to consider that. So I'm hoping that will come early and before court. tomorrow morning. But in terms of the timetable and indeed the order, it seems to me that, and it may be that my learned friend Mr. Jones would disagree, but that the advocate of the court, having already addressed the issue of precedent in his skeleton argument in depth, might be the appropriate advocate between us to go first on that issue, given that it is such a crucial issue in the case. And that what I wouldn't want to do is necessarily, excuse the pun, trespass on his good work, repeat and perhaps do a disservice to his good work.
You can sort it all out amongst
If you're happy,
yourselves.
if you're happy with us sorting it out,
You can
in
sort
order
it
to
out
ensure-
amongst yourselves and tell us what you've decided in the morning. And if you really can't decide amongst yourselves, then we will decide. But
I'm very grateful.
I'm sure you can. Good sense will prevail as it has so far today. Thank you.
Absolutely. Thank you very much.